Last 5 seconds. Ready? Start. As far as Rule 2(1)b is concerned, there can be no trace of doubt that it is in consonance with the provisions contained in the Act, in as much as Section 21 confers power on the central government to constitute the tribunal consisting of one chairperson and such number of members. The said fixation of the number is in accord with the Act. Rule 5 provides that there would be one chairperson and members not exceeding 4. As far as the number is concerned, the Act does not provide the number of members, and therefore, as we have stated above, the central government under the rules has the power to fix the number. There cannot be any kind of cavil over the same. The High Court has perceived, as we have seen from the impugned judgment, difficulty in accepting the validity of the two provisos of the said rule. The first proviso lays a postulate that the number of full-time members or part-time members shall not exceed 2. The concept of part-time member has been introduced by the rule-making authority. The second proviso states that the part-time members shall be appointed from among guest officers belonging to the Indian Legal Service who fulfill the qualifications prescribed under Clause B of Sub-Rule 1 of the Rule 2 of these rules. The submission of Mr. Bhatt, Learned Senior Counsel, is that when Rule 2(1)b clearly lays down that a member is or has been or is qualified to be a district judge, and that has been referred to in the second proviso for the part-time members, the same could not have been declared as ultra vires by the High Court. The Learned Senior Counsel would further submit that the term member would include a part-time member, and for the sake of convenience, the central government has framed the rules to carry out the purposes of the Act. In oppugnation, Mr. Mahabir Singh, Learned Senior Counsel for the respondent, would contend that when the specific meaning has been given to the term member by the Act and the existence of a part-time member is conceptually absent under the scheme of the Act, the introduction by the rule is totally impermissible. Mr. Singh would further submit that a member of the Indian Legal Service can only be appointed as a special director appeals, and therefore the rule providing that a member of the Indian Legal Service can be appointed a member runs counter to the provisions in the Act. At this stage, it is apposite to state about the rule-making powers of a delegating authority. If a rule goes beyond the rule-making power conferred by the statute, the same has to be declared ultra vires. If a rule supplants any provision for which power has not been conferred, it becomes ultra vires. The basic test is to determine and consider the source of power which is relatable to the rule. Similarly, a rule must be in accord with the parent statute as it cannot travel beyond it. Stop.